on Saturday, which is contrary to Article 37. Number two, the public participation was supposed to be done at the polling station level. Deputy presidents and presidents tallying ends at the polling station. Third, the notice of the constituency public participation. The court gave the orders at around 4:30. There was no notice sufficient for people in the villages to go to their constituencies. Therefore, that completely made people not to participate because they were not aware. The notice that was initially given was a notice at the constituency levels. Can that be the position that this court will uphold? I beg that the court extends the grant of the conservatory orders. Thank you very much, my lord, my lords and my lady.
Thank you.
Your Lordship and my lady, my name is Sakimpa. For the third petitioner, we'll be sharing time with my colleague, Mr. Wathuta. Your Lordship, you've already stated that the principles of conservatory orders have been eloquently espoused by my learned seniors, so I'll only put into context in our petition. Your Lordship, in the case of Peter Munya, the issue of inherent case is what I want to address using the ruling that was delivered by Justice Richard Mongo in petition E014. Your Lordship, and this is what the learned judge found upon perusing the documents, that on my motion, I had perused the file and considered that the matters being considered on impeachment of the Deputy President of the Republic of Kenya are novel. That is the first issue. The other issue by the judge was that there exists no statutory or subsidiary legislative framework for impeachment of the Deputy President. The learned judge also said that there exists no statutory framework for public hearings and public participation in respect of impeachment of a Deputy President under Article 145. The learned judge also identified another issue, that there have been several bills on public participation and also on the question of impeachment in Parliament, but such bills have never been passed. And then finally, the judge says that the law on these questions has not been settled. It is our submission, therefore, Your Lordship, that based on these issues that have been framed by the judge, this is a proper case for issuance of conservatory orders so as to preserve the substratum of the petitions. Your Lordship, the last issue I want to address is the issue of public participation. Mr. Omari has pointed out the issues which we have in our petitions, and also finally the issue of the Senate. Your Lordship, in our petition, we have questioned the legality of the Senate having taken the position that it was open for them to use the plenary route as opposed to the committee. On that basis, therefore, Your Lordship, these are serious issues that warrants issuance of a conservatory order. Your Lordship, my colleague will conclude. I thank you.
Thank you.
Yeah, thank you. Thank you very much. Very briefly, my lord. I'll just be making some remarks on the two applications for setting aside of the conservatory orders, starting with petition number 565. And looking at the prayers that are sought in that application, my lord, that application is moot. I say so because the substantive prayer number 2, was that pending the inter partes hearing of this application for setting aside, that the orders issued by Justice Chacha Mwita be varied or set aside. My Lord, we already passed that stage, and therefore that prayer is not available. Then prayer number 3, that in the alternative, this honorable court be pleased to set aside, vary or discharge the ex parte orders issued on 18th October 2024. My Lord, those orders lapsed on Friday, that is the 25th of October 2024. So just to make the court's work easy, there will be no need to consider that application. Having said that, and in view of your previous directions, that this application will be treated as a response to the application for conservatory orders, I would just like to make 2 or 3 remarks with regard to the content of that application, my lord. And I would just like to mention that paragraph 7 of the supporting affidavit sworn by the Solicitor General. Actually, it is in the ground, but then it is reflected in ground number 7, my lord. It says, Article 1 of the Constitution provides that the sovereign power belongs to the people, and that where there is a conflict between public interest and private interests, the scales of justice to tilt in favor of the public interest. To that, my remark is, the question that is before you is not about a private right. It is a more elevated constitutional question of impeachment of a president or a deputy president. Again, paragraph 8 states that the Constitution does not envisage a vacuum in the office of the deputy president, and as such, it is in the interest of justice that interim orders be stayed, varied, or set aside. My lord, Article 149 and Article 150 make very clear provisions on the vacancy of the office of the deputy president and how that is treated, even about the vacancy in the office of the president and how all that is dealt with. The Constitution is self-sufficient with regard to vacancy in the executive offices. Just 1 minute. I'd like to make a remark, still to make the court's work easy, in a petition number 15. And my lord, again, that application is moot. I had to check the one that is on CTS just to be double sure. And the substantive prayers that are sought are prayer number 3. It was an interim order pending inter partes hearing of that application. My lord, again, we are beyond that stage. We are already at the inter partes stage of the hearing. So the remaining prayer is prayer number 4. And allow me to read it verbatim. That this court be pleased to set aside, review, or otherwise vary grant the ex parte orders issued on 18th October 2024 by Honorable Justice Mwongo Richard Mururu in Kerugoya Constitutional Petition number 15, pending the hearing and determination of the appeal. My lord, what the National Assembly clearly did not disclose is that after these orders were served on them, they went and filed an appeal. And then filed this application to stay the conservatory order or set it aside pending the determination of the appeal. That has not been disclosed to the parties. It has not been disclosed to the court. So you have no prayer for setting aside of the conservatory order pending the hearing of the petition or pending the hearing of the application for conservatory orders. So again, that application is moot. Turning to the content of that application, in as far as it is a response to the application for conservatory order, firstly, The decision or the subject of the petition before that court was the proceedings before the Senate. Then again, the National Assembly was not necessarily the aggrieved party, but again, they cried louder than the bereaved. Again, if you look at paragraph 6 of the supporting affidavit, shown by paragraph 6. The applicant is aggrieved by the order of 18th October 2024 and seeks for the order to be temporarily set aside. Not entirely, my lord. Temporarily set it aside, pending the hearing of the appeal. My lord, that is not an appropriate ground, because no appeal has been placed before you. At paragraph 7, which is a serious misconception. Yes, my lord.
You had very few minutes. I think you have exhausted them.
Judge, I beg only two. Only two, Judge. Thank you. At paragraph 7, you realize another basis of making this application, which is a very serious misconception. And it says, a presidential system of government works based on the doctrine of collective responsibility. This is a constitutional democracy that we have. The doctrine requires members of the cabinet to work in unison for the sovereign and promote the collective policy agenda. In pure presidential systems, which is not ours, the president retains the discretion to dismiss a member of cabinet who falls short of the expectation. Well, one of the reasons why we have the current constitution is to prevent this very mischief. So, we can clearly now see the underwriter of all this impeachment process. It is the president who decided a member of the cabinet should not be here. So, this is a process that is...
Objection, that is evidence from the bar.
I'm just picking a paragraph in the supporting affidavit.
Mr. Wathuta.
Yes, Judge.
Please conclude your remarks.
Very well. Thank you. Yeah, and even more worrying is paragraph 8. Additionally, reinstatement is inconceivable where the member of the cabinet has lost confidence of the sovereign and parliament. My lord, Article 150 sets the ground for impeachment of a deputy president. Lack of confidence is not one of them. Lack of confidence by parliament in the deputy president is not one of the grounds. So we can clearly see the reason why we have the impeachment process. Who is the sovereign? The people. When did the people say we have lost confidence in the deputy president? So all these other grounds, as we will demonstrate at the hearing of the petition, is just a facade, it's just a face to hide the real intention of members of parliament saying we have lost confidence in this particular person. I do not want to go to paragraph 9, but again, those are matters that we'll deal with at the petition stage. But all in all, my lord, you only have two applications to consider, the ones for conservatory orders. The one for setting aside the conservatory orders, my lord, I've made your work easier. Most obliged. Thank you very much.
Thank you.
May it please the court. My name is Dr. Eboso. I'm from Vihiga, and I'd like to...
Dr. Eboso, you'll address us for only 5 minutes, please.
My lord, I will do my best, but I promise I will not repeat anything that has been said. My lord, I'll go straight to the points. One, what is on trial, or what is at stake in the setup of an interim conservatory order? My lord, I'd like to inform the court that what is on trial is a Bill of Rights. And Article 38 of the Constitution provides that a person has a right to vie and be elected for office, and if elected, has a right to hold that office. My Lord, that is one of the things that is on trial, but I will ignore that for now. What is at stake, because a conservatory order is supposed to preserve the substratum, is a right to a fair trial. My Lord, the components of a fair trial include the tribunal that is independent. It includes the process and the outcome. My Lord, the outcome includes the remedies that are available by law to the individuals before the court. One of the remedies, the material remedies that the parties before this court are seeking, is reinstatement of Deputy President Rigathi Gachagua to office. Therefore, and I will demonstrate when I talk about the Wajir case at the end, that once a new person assumes that office, that remedy is completely taken off the table. And that means these conservatory orders are actually at the heart of a fair trial. And a fair trial is among the rights under our constitutions that cannot be limited. It is not that a fair trial is absolutely not limitable, but that the state through its action or any person through their deliberate action cannot limit the right to a fair trial. Why do I say this? During a trial, the witnesses may die naturally. COVID may happen and cases are delayed naturally. That is extrinsic and it may affect a fair trial. But the court must never do anything deliberately that would impede a fair trial or that would be imputed as limiting the right to a fair trial. So, my Lord, by lifting this conservatory order, you will be actually limiting the rights of the petitioners to a fair trial by taking away a very material remedy to the remedies that are available to them. I'd like to talk about what is the place of the Bill of Rights under our Constitution and the concept of public interest, because it has come up very much. Now, our Bill of Rights under our Constitution is very fundamental. The Bill of Rights, the chapter on the Bill of Rights, is the only chapter under our Constitution that has its own doctrine of interpretation. And the Bill of Rights is enjoyed individually as per Article 19, is by individuals. It is actually antithetical to the concept of human rights and individual human rights to say that the Bill of Rights will be enjoyed at the behest of a public interest. They are actually specified there expressly, especially to be enjoyed in spite of the public interest. So I feel like the argument that the public interest should be balanced against the Bill of Rights is antithetical to the very concept of the Bill of Rights. The limitations of the Bill of Rights is captured in Article 24, and I would have read the entire article for us to see. But the provisions that it provides is that the Bill of Rights will not be limited except by law, and then only in a manner that is reasonable and justifiable. My Lord, the public interest that has been propounded by at least the response by the Attorney General, or the application that by the Attorney General, did not disclose the legal basis of that public interest. In fact, it was just general. And it brings me to the question. It reminds me, in 1945, the Supreme Court of the United States was faced with a case about the Anti-Obscenities Act or Anti-Pornography Act. And Justice Stewart, unable to define what pornography is, in his concurring opinion, wrote, "You will know it when you see it." My Lord, that is the kind of public interest that the Attorney General is asking us to use to balance against the Bill of Rights. A public interest that we cannot really tell what it is. My Lord, the public interest that should be able to limit the Bill of Rights must be founded in law. There must be a legal basis for which you're saying this is a public interest. Whatever the Attorney General has propounded, in fact, has not even specified. It must not be vague. It must be very specific so that we can assess its reasonability and whether it can actually be justiciable or it's justified within a democratic society. My Lord, I saw in the response by the National Assembly, the public interest has been a bit defined and has been stated as the fact that we do not have an IEBC. My Lord, that is not a legal question. The other issue was that we cannot stay without a deputy president. My Lord, as had been propounded earlier, kindly allow me 2 minutes. As has been propounded earlier, my Lord, the Constitution allows us not to have a deputy president for at least 60 days, in fact 74 days. So we don't yet have a legal crisis as we speak. We may have a political crisis, but it's not a legal crisis. The absence of an IBC is a political crisis that cannot be brought before the High Court, a court of human rights, as for that to be balanced against human rights. My lord, the political arms of government are the ones best placed to deal with a political crisis. And tomorrow they can appoint an IEBC if really there's a political crisis. Finally, my lord, I would like to bring attention to 3 cases by the Supreme Court. The Munya case, Martha Karua case, and Speaker Mate case. Because they kind of explained how conservatory orders ought to be interpreted. And my lord, what I read from those cases is that a court order through a conservatory order cannot overthrow the constitutional values and constitutional imperatives. A conservatory order by the court fetters discretion, constitutional or statutory discretion, never constitutional obligation. And so, my lord, in the context of this conservatory order, the conservatory order cannot be interpreted in a manner as to freeze time. Because one of the things that is considered by all parties in this case is that an impeachment did happen. And it's presumed to have happened lawfully until this court finds that it did not happen lawfully. By that, the Constitution is very express that the office will fall vacant. And so that one, however much a court attempts, it cannot constrain an edict of an imperative of the Constitution. So the office is vacant as we speak. However, time started running, and the president had 14 days, a discretion of 14 days. The court order can fetter that discretion, and where it seems to the court that the discretion was abused and rushed in order so that you can avoid the rule of law and whatnot, the court can make the conservatory order to be deemed as if the action was done as if that abuse was not there. So that the president still had the 14 days, and so the time is counting. Parliament will still have 60 days. Now, at the end of the 74th day, this court's conservatory order, however much it tries, it cannot extend beyond that. Finally, my lord, I want to talk about the Wajir case because nobody has talked about it, and it was part of the Attorney General's application and response. The Wajir case relates to a governor who was impeached. The deputy governor assumed office and then even nominated a new deputy governor, and then later on the High Court found the impeachment to have been unlawful and reinstated the governor back to office. My lord, there is a distinction, both a constitutional distinction and even a procedural distinction in the 2 cases. In the Wajir case, the court had issued a conservatory order against the assumption of office, which was defied. But aside from that, because that still is arguable as to whether a conservatory order can do that, there is the question of part of the rule of law and a fair trial is the enforcement, the enforceability of a court order. Now, a court order may be enforced against the deputy governor or the governor of a county. But as per our constitution and as per the holding of BBI in the BBI case, the presidency is absolutely immune. No amount of court order will be issued that will be able to be enforced against it. Because who will enforce the court order declaring the office of president vacant? My lord, it's the political arms of government that can deal with that. And that might be one of the issues that are political questions that the court cannot really address. So, my lord, as far as the office of the deputy president is concerned, such an order cannot come from this court. We cannot allow the conservatory order to be lifted, and then we imagine that we will be able to enforce an order removing Professor Kindiki from office. My lord, thank you very much. I'd like to ask my co-petitioner, I think petitioner number 12.
I wish to make an application under Article 57.